I'll say welcome, since it seems that you come from all over the world. So I have to say just welcome and not good morning or good afternoon. My name is Giuseppe Nessi, and together with Elena Fasoli, I am the co-organizer of this webinar on climate change and sea level rise, legal consequences from the law of the sea, statehood, and affected persons' perspectives. I'd like to welcome all the participants to this webinar. This webinar is organized by the University of Trento and under the patronage of the Italian Ministry of Foreign Affairs and International Cooperation. This event is also part of the activities of All for Climate Italy 2021. I would also like to thank the Italian Society of International Law, the Italian Society for International Organization, the International Law Association and its Italian branch. The Dean, Professor Fulvio Cortes, sends his apologies for not being able to make it today. We regret that we have not been able to organize this meeting in person, but we are sure you will forgive us and understand that the unforeseeable circumstances we are living in obliged us to adopt a, so to say, precautionary approach. However, we hope that this is going to be only the first of several events on these topics, and we can reassure you that we are planning a new meeting, this time in person, hopefully, in 2022. I'll not dwell extensively on the importance of the topic under discussion in this webinar. This summer, the ICCP published a new report. Last week, the UN Secretary General opened the 76th UN General Assembly session with an impressive appeal to all member states to act with regard to the terrible consequences of climate change, including sea level rise. Climate change and the pandemic have been both considered by the President of the Council of Ministers of Italy as scourges that must push states to find solutions. During this week and until yesterday, Milan has hosted a very important event, Youth for Climate, in which representatives of the youngest generation have written a document that will be adopted by the ministers participating in COP26 that will take place in Glasgow in a few weeks, thanks to a partnership between the UK and Italy. Thanks also to the studies and reports of the International Law Association, and namely the Committee on International Law and Sea Level Rise, whose chair is present here today, and the work of the International Law Commission, also represented by several of today's participants, a new collective sensitivity has emerged on the interrelated topics of climate change and sea level rise. This sensitivity was confirmed by the strong support offered by the General Assembly and its sixth committee to the inclusion of sea level rise and international law among the topics to be discussed by the International Law Commission. This webinar is aimed at analyzing some of the numerous legal and scientific aspects of those interrelations. I refer to the implications for the law of the sea, for the continuity or loss of statehood, and for the affected populations. Before introducing the participants to the webinar and further elaborating on the modalities of this event, including the possibility of asking questions to the participants, allow me to give the floor to Professor Gabriella Venturini, the President of the International Law Association, Italian branch, who, as I told you, is sponsoring this important event, and she will be followed by Professor Enrico Milano, who will talk from New York. But please, Gabriella, Professor Venturini, the floor is yours.
Thank you, Giuseppe, and good afternoon, everyone. or good morning, or good evening, I don't know, but welcome. I am very happy on behalf of the Italian branch of the International Law Association to have this opportunity to say a few words about this indeed very, very topical seminar. Today we are all aware that the rate of the rise in sea level is worrying, is challenging, and this is a challenge that must be addressed by international law, because the risk of sea level rise does not affect only certain populations. It is a risk for humankind, because the sea is our common heritage. This is why the International Law Commission, as you, Giuseppe, have pointed out, has included this topic in its program of work, and I am particularly pleased to see two distinguished members of the ILC which are taking part in this webinar. Dr. Oral, Professor Calvo Teles. I also would like to point out again the role of the Committee on International Law and Sea Level Rise of the International Law Association. You, Giuseppe, are now a member of this committee. And as you said, Professor Davrovidas, its chair, is also participating in the webinar. And there are other scholars, experts of international renown, such as Tullio Treves, professor, judge, who is one of the most respected authorities in matters regarding the law of the sea. All this promises a very in-depth and inspiring discussion, a discussion that I am looking forward to listening to and to learning from. I therefore will not say more, time is limited, and I immediately give the floor or the screen, better if you prefer, to you or to Enrico Milano, whoever is now entering the stage. Thank you all. See you on screen.
Thank you very much. Thank you, Gabriella. And yes, I'd like to invite Enrico to take the floor. Enrico Milano is, as I said, speaking from New York, where he is the legal advisor of the mission of Italy to the United Nations. So Enrico, the floor is yours.
Thank you, Professor Nesi. Thank you, Pepe, for the invitation today. And very good to see many colleagues, or I should say to meet many colleagues and friends, albeit virtually today. And a very good afternoon to all distinguished speakers and participants. And thank you, of course, for the opportunity to address you in the context of the Conference on Climate Change and Sea Level Rise organized by the University of Trento. Today's conference is a very timely and significant academic initiative, which, as you mentioned, Pepe, is organized under the patronage of Italy's Ministry of Foreign Affairs. And also, I'd like to point that it comes in the run-up to the 26th Conference of the Parties to the UN Framework Convention on Climate Change, which will meet in Glasgow later this month under the partnership between Italy and the United Kingdom. The timing is also particularly fortunate, seen it from a perspective of New York, as today's webinar takes place a few days before the opening of this year's session of the 6th Committee of the General Assembly, in which states will comment on the latest report of the International Law Commission, including the part dedicated to the important study of the legal implications of sea level rise. Climate change related to sea level rise, as we know, is a current phenomenon. It has far-reaching natural, social, political, and economic consequences on maritime areas, on territories, and on populations. And sometimes we know it can become an existential threat, especially for small island developing states. And yet we know that its legal implications are still to be fully explored. And in this respect, I think we must be fully appreciative of the endeavor undertaken by the LC and the quality of its work so far. While we know that the areas of study identified by the LC present very distinctive features in terms of existing legal instruments and regimes, I think they can be explored under the lenses of stability, adaptation, and evolution of international law. That is the extent to which those legal regimes and instruments are capable of addressing the most pressing needs of the international community. And of course, the LC work is going to be very precious in this respect. And ultimately, it will be for the community of states to come together and identify the most appropriate legal solutions when not guaranteed by existing legal frameworks. On a more personal note, as a university professor now seconded to the diplomatic work, let's put it this way, I'm very pleased that the academic community in Italy, in this case, the University of Trento, under the able guidance of Giuseppe Nesi, is fully engaged with sea level rise. Both because climate change related coastal erosion is a reality of our country, and sometimes also having important impacts on the conservation of our and preservation of our cultural heritage. We had very recently in June, in the framework of the UN informal consultative process on the oceans, a very interesting presentation on how sea level rise is affecting cultural heritage in the city of Venice. But of course, we know that in general, this is something in terms of its direct consequence is also a very important challenge for the international community as a whole, as Gabriella Venturini has rightly pointed out. I'm sure that the webinar will provide useful lessons and insights, including for academics, legal experts, and governmental officials, and spark a fruitful discussion. And I thank you for your attention, and I hand back to you, Peppe. Thank you.
Thank you very much, Enrico. Thank you for these words, and also for the nice words addressed to the University of Trento. You know how important this university is to us, I would say. And we continue now with our program, and our program will be mainly divided in 4 sessions, so to say. The first will be devoted to setting the scene, and those who are going to talk in this part of the webinar are Elena Fasoli and Thomas Fröhlicher. Then we will have another 3 sessions on the work of the International Law Commission on sea level rise in relation to international law. But before going ahead, I would like to give just a few, a very short presentation of our first panelist. Elena Fasoli is Associate Professor of International Law at the University of Trento, and she was a member of the UNEC Aarhus Convention Compliance Committee from 2014 until 2017. Previously, she was research and teaching fellow at Queen Mary University of London and senior researcher at the University of Bologna. Elena has been external consultant to the Ministry of Environment of Italy from 2009 to 2013. This is from the legal side. As regards science, Thomas Fröhlicher is currently a Swiss National Science Foundation assistant professor at the Climate and Environmental Physics Division of the University of Bern and the head of the Ocean Modeling Group. He is interested in marine ecosystem carbon-climate interactions with focus on ocean extreme events and their impacts on marine organisms and ecosystem services. He is the recipient of the 2019 Theodor Kocher Prize of the University of Bern. So I would say that we can start with Elena, who is going to talk about the international legal framework on climate change and sea level rise. Elena, please.
Thank you, Professor Nesi. Welcome to you all, also from my part. Thanks for being here with us today, and many thanks especially to our distinguished lineup of speakers for accepting our invitation to contribute to the discussion of such an important topic today. So, as Professor Nesi said, my role is to set the scene. I will make some introductory remarks to link the international framework of climate change with the sea level rise within the work of the International Law Commission, and I will bring forward a couple of questions for the discussion of the panelists later on. So, as we will be hearing from the science in a few moments, Thomas, you represent the science for us today. Climate change, also linked to atmospheric pollution, is the cause, or at least an accelerating factor, of certain effects. Amongst these effects, there are the so-called slow onset events, such as, for example, sea level rise, which in turn is also recognized as a disaster. In one of the many webinars that I have followed this year, like I think probably many of you, it was very well said that sea level rise is the most measurable indicator of how much we are failing in the climate change area. So we have a cause and we have an effect. How did international law address these two? Well, first of all, the cause, climate change, was approached by adopting binding rules negotiated by states. Lavanya Rajamani, for example, recently said that having in place tailored obligations on mitigation would be the first best option. Unfortunately, as we know, the obligations on mitigation contained in the Paris Agreement suffered the major limitation that they are due diligence obligations rather than obligations of result. In fact, Lavanya Rajamani, she was referring to climate litigation as being the second best option because the first option is failing. Anyway, this was the political compromise in relation to the so-called nationally determined contributions, which was reached at the time in Paris. And it is of just a few days ago that we have the news that the full version of the NDC's synthesis report has been released by the UNFCCC Secretariat. And it is clear that it is still not enough and much more should be done from states. But the international legal framework on climate change also addresses the effects of it, because slow onset events like sea level rise are referred to in probably the second most controversial chapter of the Paris Agreement, which is Article 8 on loss and damage. And you'll probably remember how controversial it was and still is, this article, as to whether it had to be considered adaptation or not. And the main concern was that it could contain aspects of state responsibility and compensation. And of course, there was a huge opposition to that. To better understand how international law addresses climate change and sea level rise, which is the main issue of discussion today, it could help to zoom out a little and to read climate change also within the broader context of the protection of the atmosphere. Because if we look at the broader regulation there, we find binding rules, including emission targets within timeframes, therefore obligations of result. Although the main problem is the fragmentation of the instruments, because some of them, they have only limited geographical coverage, they are regional in character. In other cases, the regime involves only certain activities or certain substances. One example for all, the Montreal Protocol, which is a global and very successful instrument, but it covers essentially chlorofluorocarbons. So the picture is very scattered, and this was the reason why in 2013, the topic protection of the atmosphere was included in the work of the ILC. And the intention was to cover the subject more holistically, ideally through the adoption of a convention. Now we have the new draft guidelines on the protection of the atmosphere, and it rests to be seen what their fate will be. If we zoom back into our topic of sea level rise, the approach of the ILC was similar, but for some aspects also completely different from that of the protection of the atmosphere, because the envisaged output was from the beginning not a foundational document for a treaty, but a report accompanied by a set of conclusions and recommendations. And the work of the ILC, which also acknowledges the work of the International Law Association, is undertaken by an open-ended study group with co-chairs in relation to the different subtopics, instead of the more traditional special rapporteur way of proceeding. Now we have, as we'll be hearing, the first of the issues paper drafted by 2 co-chairs on law of the sea, and the other to come on statehood and protection of persons affected by sea level rise. Let me just say that the members of the ILC are maybe the ones more resembling to scientists in the work that they have to undertake. Because like scientists, they are in search for practice with their microscope, codification, or with their telescope when it is progressive development. And we know how important scientists for policymakers are, or at least they should be. So in light of this, I cannot help but ask you, and of course I'm not addressing this question only to the ILC members, but to all panelists. How much do you think that this work of studying some of the legal questions of one of the effects of climate change, even though with strict limitations, because we know, and it was clear from the syllabus that of the study group, that climate change per se could not be addressed. But how much do you think that this work can have any way an impact on the cause of the problem, meaning climate change, so that states have are somehow persuaded to reduce more their greenhouse gases emissions? I suppose that this question has to do with possible indirect effects of the work of the ILC on states in influencing their behavior. And of course, this applies more to the work of the ILC rather than that of the International Law Association, because of the more direct relationship of the ILC with the states in the 6th committee. So this was the first point for reflection and the first question to the panelists. And the second point is this. From the angle of analysis which I have chosen for setting the scene, sea level rise is dealt with by the International Legal Framework on Climate Change and also by the study group of the ILC. On the one hand, we have the activities undertaken within the strategic work streams of the so-called Warsaw International Mechanism for Loss and Damage under the Paris Agreement, which is the multilateral instrument established to address loss and damage under Article 8. There are activities here, for example, undertaken by the Task Force on Displacement or by the new expert group on slow onset events. On the other side, we have the legal solutions that have been already and will be developed by the ILC through the study group on sea level rise. Of course, very different regimes, completely different approaches and methodologies, because at the UNFCCC level, they only map the existing actions and policies to address slow onset events and human mobility, and they report them back to the COPs. The ILC also maps, but they map the relevant legal questions raised by sea level rise in order to propose legal solutions. Essentially though, all activities, if we look at them holistically, they point to solutions for facilitation and cooperation, technically pertaining to the realm of the so-called liability for lawful acts, not state responsibility, God forbid. And with a clear prominence of the procedural duty or principle of international cooperation, which is the cornerstone of so many international instruments, including, for example, the draft articles on the protection of persons in the event of disasters. So in light of this, and that's my second question, I'm not here raising the issue as to whether an approach of cooperation instead of one based on state responsibility is the right one to follow, or I won't even raise the issue of the progressive proceduralization of the protection of the environment that we are currently witnessing, even when we deal with such pressing concerns of the international community as a whole. Instead, I would rather ask probably a more technical question, whether there is a link between the activities of the two regimes, because it is often referred to a certain level of compartmentalization of the various interventions in relation to the same problem. And so I was wondering, is there collaboration between the UNFCCC activities on the one hand, that I just mentioned, and the study group, especially considering that the study group is searching for elements of practice and other relevant information? So that was my second point for reflection for later on, and my second question. Thank you very much. And with this, I leave the floor to Thomas, to the science, the science of climate change and sea level rise. Thank you.
Very well. Just a moment, since I forgot that those who want to put questions, they can do it using the box questions and the chat box at the here in the screen. So those who want to put questions, please use questions and at the chat box, in the chat box, and we will, of course, read them at the end of the presentations. Thank you. Thomas, floor is yours.
Yes, please allow me to share my screen. Can you see my slides well? Okay. Okay, also good afternoon from my side, and thank you very much for the invitation. It's actually a great pleasure to give an update on the science of climate change and in particular sea level rise. And before I start with that, I just want to remind everyone why we are actually really worried about sea level rise. I mean, we know today, or at least 10 years ago, when we actually did someone did the calculation, 680 million people live in low-lying coastal areas. So that means 10 meter above, maximum 10 meter above sea level. And this number will actually increase to about 1 billion people in 2050. So it's actually quite important to understand how sea level has changed in the past and how it's going to change in the future. So when we look at the climate, how is it changing? I picked two figures from the recent IPCC report, which came out two months ago. So on the left side, you see the atmospheric CO2 concentration. So the CO2 in the atmosphere reconstructed over the last 2000 years, so the last 2 millennia. And on the right side, you see the temperature changes over the same period. So the IPCC has actually concluded that it's unequivocal that human influence has warmed the atmosphere as well as the ocean and land. And you can see that the CO2 has actually varied over the last 2000 years, actually varied between about 275 and 285 ppm. And since the start of the industrialization, so through the burning of fossil fuel, and also through to CO2 emissions due to land use changes, actually atmospheric CO2 has risen to today about 410 ppm. And together with the rise in methane concentration and N2O concentration in the atmosphere, this has led to a strong increase in temperature of about 1.1 degrees measured at the global Earth's surface. And this warming is unprecedented in more than 2000 years, when we go back 2000 years. And it is actually also the warmest multi-century period in more than 100,000 years. So we are really going in a period which is really unprecedented in terms of global temperature, and also in terms of the composition of the atmospheric greenhouse gases. So in terms of sea level, I will actually highlight some results from the recent IPCC report, which came out two months ago on the right side. But I will also show you some results from the IPCC special report on the ocean cryosphere, where I was a lead author in chapter 6. And here are actually the highlight statements I think are most relevant in terms of sea level rise. They concluded sea level rise has accelerated since the late 1960s, and it raises actually now faster than in any prior century over the last 3 millennia. Sea level has risen by about 20 centimeters since the beginning of the Industrial Revolution, and human-caused global warming was actually the main driver of this increase. Sea level will further accelerate, reaching up to 0.6 to 1 meter in 2100 relative to today if emissions are not sharply reduced. And extreme sea level events, which actually occur rarely during high tides and intense storms, such as tropical storms, for example, will become much more common. And that means that many low-lying coastal cities and small islands will be exposed to risks of flooding and land loss annually by 2050, especially without strong adaptation. And I will show you the underlying science underlying these statements now. So when we look at the global mean sea level reconstructed over the last 150 years, you clearly see it has actually increased by 20 centimeters since the beginning of the 20th century in all reconstructions we have at hand. And what is actually important to note is actually the sea level is not just increasing, also the rate of increase is accelerating. So we had about an increase of about 1.3 millimeter per year in the early 20th century. At the end of the 20th century, it was about 2 millimeter per year. And now it's already 3.7 millimeter per year over the last 10 years. So it's actually accelerating, and things happening faster than previously. And if you put that also into the context of the last 2 millennia, so we are here today, you clearly see that also sea level is really, the sea level rise is unprecedented in the last 2,500 years. So sea level was never as high as we measured today over the last 2,500 years. So what are the causes? The first cause is, well, the ocean is warming up. It takes up more than 90% of the excess energy which accumulates in the atmosphere due to the increase in greenhouse gases. And this warming makes the water less dense, it expands, and therefore we get sea level rise. And we can measure that very well. So you see here the Atlantic Basin, the Indian Ocean, and the Pacific Ocean. And if it's red, that means you have higher temperatures. You clearly see that at the surface ocean, it's more reddish. That's because the excess energy penetrates from the atmosphere into the surface ocean and then to the deeper ocean. We also have some regions which actually the ocean has cooled down. That's mainly because the circulation has also changed, and that also changes then the distribution of the water within the ocean. And the second main contributor to the sea level rise are the melting of ice sheets, so the Greenland Ice Sheet, the Antarctic Ice Sheet, and the melting of glaciers. And here we usually call that the biggest diet. So they are actually undergoing a really big diet, these two ice sheets in Greenland and Antarctica. So here in green, you see the Greenland mass change of the ice over the last 30 years. And in black here, the Antarctic ice sheet. And the Greenland ice sheet has lost about 5,000 gigaton of ice mass since the last, over the last 30 years. Half of it has also been lost in Antarctica. And we know all very well when we go to the mountains that also the glaciers are losing mass. And actually they lost about 6,200 gigatons. So together, about 50% of the sea level we have measured over the last 40 years is due to the ocean warming. And the rest is actually coming from the ice sheet mass loss in Greenland and Antarctica and the glaciers. And a small part also comes from the changes in terrestrial water storage. But now the question is, what is ahead of us? And for that, we use Earth system models, the most complex climate models we have at hand. And what do they actually project? Well, they project in all future greenhouse gas scenarios that sea level will continue to rise. So there's no scenario we know where the sea level will actually decrease at the moment. So they all project an increase in sea level of about when we go a high greenhouse gas, no mitigation emission scenario, we will have another 1 meter on top of the 20 centimeter by the end of this century. When we follow a scenario which is more in line with the Paris Agreement, so these blue scenarios here, we will have an additional about 30 to 40 centimeter sea level rise on top of the 20 centimeter we have at the moment. And you also see that the IPCC has now for the first time also made this dashed line here. So that's a low likelihood, but a high impact storyline. So when the ice sheet around the Antarctic are actually disintegrating faster than what the models actually show at the moment, because the models do not represent all the processes which are relevant to really accurately simulate the Antarctic ice sheet, then we can actually not rule out a sea level rise of 2 meters by the end of this century. And I think important is actually it will not stop here in 2100. So the slope here is still positive. When we go to 2300, actually under a blue scenario, it's more like the Paris Agreement, and the red scenario, which is a high emission scenario. So under the blue scenario, we will get an additional 50 centimeter by 2300 at minimum, and a maximum in a high greenhouse gas emission scenario plus 7 meter sea level rise. And if we also include the disintegration of the marine ice sheet around Antarctica, so this low likelihood but very high impact storyline, we cannot rule out the sea level rise which is greater than 50 meter by the in 300 years. Of course, this is really unlikely, and there is a lot of in the science community to really understand if that's really possible or not, but we cannot rule it out at the moment. And my last point I want to make is it's probably not just the mean sea level which worries much. It's actually these extreme sea level events, which also happened in Venice, for example, 2 years ago, which have a big impact. And they will actually strongly increase in the future as well. And that we have shown in this special report in the ocean and cryosphere 2 years ago, that actually many low-lying megacities and small islands are projected to experience historical centennial events. So these are events, extreme sea level events, which occurs every 100 years. They will occur every year in 2050 under every greenhouse gas emission scenario. And these extreme sea level rise will then be exacerbated by projected increase in the tropical cyclone intensity, and also in increase in precipitation, which we expect due to the increase in humidity in the air due to warmer temperatures. So I think that's a short summary of the latest science about climate change and sea level rise. So thank you very much also from my side.
Thank you very much, Thomas. I must say that it is really frightening. We experience on an everyday basis, actually, many of the phenomena you were talking about. Of course, the medium-long run, if things continue to be as they have been in the recent years, will be very difficult time. But I thank both of you, Ellen and Thomas, for giving us the structure of the elements we are going to discuss today, both from the legal point of view and from the scientific point of view. Now we start another panel, which will focus on the work on the International Law Commission on Sea Level Rise in relation to international law. And we will focus on, first on law of the sea implication. In order to discuss this issue, we invited Nilufer Oral, Bogdan Aurescu, unfortunately cannot be here. He's also a member of the International Law Commission, and Professor Tullio Treves, who is, as Gabriella said, a former judge of the International Tribunal for the Law of the Sea, but much more, I would say. However, let me read just a few lines on the bio of both Nilufer and Tullio. Nilufer is today a member of the International Law Commission and co-chair of the study group on sea level rise in relation to international law. She's the director at the Center for International Law of the National University of Singapore and a distinguished fellow of the Law of the Sea Institute at Berkeley Law. She's also the author of several works on different topics of international law. Tullio Treves is Professor Emeritus of International Law at the State University of Milan, after being full professor in the same university for more than 30 years. He was a judge of the International Tribunal for the Law of the Sea for almost 15 years, and within the tribunal, also president of the Seabed Disputes Chamber. He acted as counselor or as arbitrator in several interstate disputes Tullio is the author of numerous books and articles on many aspects of public and private international law. And I must say that on a personal basis, Tullio was also one of my predecessors at the Permanent Mission of Italy to the United Nations, and also one of the predecessors of Enrico Milano as legal advisor some years ago. So Niloufer, the floor is yours, and I thank you again for participating in this meeting.
Thank you. Thank you so much, Giuseppe. And what an honor and privilege, and may I say great pleasure to be part of this very important conference that the University of Trento has organized. So I thank you and your team for all the efforts that have gone into this, and of course as well the Italian Ministry of Foreign Affairs. Also, I want to thank Elena and Thomas for setting the scene so brilliantly on this very interesting questions and points that you've raised, and I hope we will get to those, Elena. And of course, Thomas, each time I hear about the science aspects, it really just cannot underline the severity of the situation. And I think what we really have to understand, this is not a theoretical issue. It's a real one. It's happening. And the scary part is, and I think Tomas was saying that even today, if we stopped all emissions, we're still going to have sea level rise. So ultimately, where is international law in this picture? So I'm going to, unfortunately, my dear colleague, Bogdan cannot join us. He has to be with the president of Romania. So that's the only reason. Otherwise, he is truly very committed to the work we do. So I will have to represent him. And so you have to hear me a little longer than normally planned. But can I say what an absolute, I mean, I have known Tullio Treves for many years, and he is really an icon for all of us. So to be with him today is an additional treat and pleasure indeed. So I'm going to focus on the work of the International Law Commission in relation to sea level rise and the law of the sea. And I know my dear friend and colleague Patricia, she will be talking about the other topics. But before I do so, I also want to start off, because I know that we have the International Law Association represented here and the Italian branch, and really start off by acknowledging and commending the absolute excellent work that the International Law Association has done, first beginning with the baseline committee, and now, of course, the ongoing work of the Sea Level Rise Committee, and Devora, a dear friend and colleague, who is chair and co-rapporteur of that committee, and all of you who are representing the committee here today. That work really was groundbreaking, and I think it's important to acknowledge that. But the commission, when we took it up, I think it's an important continuation of that work, because the ILA is a private organization, but as many of you, and perhaps all of you know, the International Law Commission is a subsidiary body of the United Nations General Assembly. And so the work that the commission does, and that was mentioned earlier, really has direct relationship with states through the Sixth Committee and otherwise. And so we have a direct feedback that is very critical, because as was also stated earlier, while we can be doing the mapping and the scientific work, it is going to be in the hands of the states to resolve this very real and urgent challenge that we're all facing. And I underline, sea level rise is not a regional issue. It is affecting everywhere. One, directly those that are in coastal areas, but indirectly too, and this is a topic that will be taken up through, I think, the protection of persons. So in relation to the law of the sea, just very briefly, sea level rise, and depending, of course, on how much there's going to be, and we have different scenarios, the coastal configuration of a state will change. And as a consequence, the baseline, and these baselines are very important for how we measure and establish maritime zones and maritime boundaries. Very valuable very important: territorial sea, contiguous zones, exclusive economic zones, continental shelf, and the demarcation between that, the high seas, that is areas beyond national jurisdiction, and of course, the continental shelf, extended continental shelf, and the area, the common heritage of humankind. All of these are boundaries. They're also boundaries of relationship with other states, but they all depend on this baseline. And this baseline is vulnerable. The baseline and the base points is very vulnerable to sea level rise. And that means that the very valuable maritime entitlements are also vulnerable. In addition to that, so the question is, how does this impact the coastal states' rights to these entitlements, prescriptive competence, enforcement competence, but also for third-party states? Another important issue, the status of islands. And I'm not going to go into too much of the technical nitty-gritty, but we know that under the Law of the Sea Convention, to be an island entitled to all the maritime zones, there are certain conditions of being able to sustain human habitation and an economic life of its own. Now, the problem is with sea level rise. In addition to losing territory, land territory, could the island become uninhabitable under the Law of the Sea Convention, paragraph 3, either because of loss of territory or because saltwater intrusion into freshwater supplies could make it uninhabitable for humans and also supporting economic life of its own. And this will have an impact on the entitlements, because then as a rock, the island devolving into a rock could lose, and these are the questions we don't know, the exclusive economic zone, and while in terms of the continental shelf, that depends again on this whole issue of permanency. There's also the question of archipelagic states. And archipelagic states, if they fulfill certain conditions, can be entitled to draw archipelagic strait baselines, which then encloses an area that becomes archipelagic waters and gives these archipelagic states sovereignty rights, very valuable sovereignty rights over an area. All of this stands to be at risk because of sea level rise. And so these are the legal issues, which very real consequences that have been first taken up by the International Law Association and now with the International Law Commission. So now I want to give just a little bit of a history of how the Commission took on this topic. First of all, I have to say that we have to recognize the leadership that the PISAs, the Pacific Island Developing States, have had in bringing the importance and the challenges of sea level rise to the attention of the international community. It was in the first Ocean Summits some years ago that they first made their request, actually I was there, for the International Law Commission to take up the issue of sea level rise. But I have to tell you, historically, they have been raising this issue since 1989. The Small State Conference issued a declaration back then. It was hosted by Maldives, 4 states for the international community to address sea level rise, and that is decades ago. However, luckily we've had tremendous support from the 6th Committee starting from 2017, and when I was elected and Patricia and my other co-chairs Bogdan to the commission, it turned out that we all shared this interest to pursue this topic. And what we did is we proposed to the commission the topic, but also that instead of the usual 1-person chair or a special rapporteur, that we have a 5-person study group. And the study group was selected because there was some concern in relation to what role we would play, particularly because of the existence of the 1982 Law of the Sea Convention. But everyone was very comfortable with a study group format. Now, this is the first time that we've had 5 co-chairs, but can I say, I think it's been tremendously successful, and it's a whole other issue concerning the working methods of the commission. And we separated into 3 topics: law of the sea, loss of statehood, which will be addressed as well in this meeting, and also protection of persons, which Patricia is the lead on that, and Bogdan and I. And also we have Yakuba Sisse from Cote d'Ivoire, as well as Juan Jose Santalario, the 5 members of the International Law Commission. Now, we had some mention already about the issue of stability and security. In 2017, the Commission proposed this topic to the 5 of us. We proposed this topic to the Commission, and there was much support in the Commission for this. And in 2018, the Commission agreed to put on the long-term working program, and then in 2019 on its current agenda. And each time that these decisions were taken, we had, of course, reactions from the 6th committee. And in 2019, I have to say, very strong support. 57 delegations, and really it came up to over 100 states, were mentioned this topic, and for the most part, they were supportive. But a very common theme that went through was the concern about stability, security, predictability, and certainty that in international relations, and also in relation to the law of the sea, including the status of the convention. Some states linked this issue of stability and security to baselines, to protecting maritime entitlements, but also to ensuring that the integrity of the Law of the Sea Convention would be maintained. So when we established a study group, it was agreed that we would engage in a mapping exercise of the legal questions, analyze existing international law, and of course, importantly, what state practice there would be. And the final outcome would be a final report of the study group. Now, and it will be divided into 2 issues paper to begin with. They're preliminary. And the first issues paper is the law of the sea. The law of the sea issues that we are addressing concern the legal effects of sea level rise on baselines and outer limits of maritime spaces, the possible legal effects of sea level rise on maritime delimitations. And recall, we have maritime delimitations through agreements and also international adjudication. Also, concerning the exercise, and this is very important, of sovereign rights and jurisdiction of the coastal state in the maritime spaces in which boundaries or baselines have been established. Also, the possible effects of sea level rise on the status of islands, rocks, and the concomitant maritime entitlements. And we also looked at the legal status of artificial islands and reclamation activities. In addition, the Secretary of the Commission undertook a study, a survey of some 250 treaties relating to maritime delimitation, and looking at the language to see if there's any indication that these treaties provided for changing of the maritime agreements, amending. And again, this has to go to the issue of whether baselines are ambulatory or permanent. And so that was an important study that was done. And also we asked for state practice from states. We received some, but it's so important, we still need to have more information on that. Now I wanna, again, because I'm focusing on the work of the International Law Commission, the first issues paper, which was completed and published in 2020 by myself and Bogdan. It is an official, and all the issues paper will be that way, official document of the UN that is translated in all the UN languages. This is important because in the past study groups, the work was not official, but we wanted to give this work the recognition and importance it deserves, even though it's a study group. format. So this is an important point to underline in the methodology. How the study group will work. We prepared the first issues paper. We had a contribution from one of our members on the practice of Southeast Asia maritime boundary practice. But the idea was afterwards that other members, the open-ended study group members, because the study group would then be open to all members of the commission, they would then contribute as well, and they did. We had many written contributions, but these are not official documents. And the first issues paper I should highlight is, of course, reflects the views of the co-chairs. It is not the view of the entire commission. And that, of course, you will see if you look at Chapter 9 of the 2021 ILC annual report, where we had a very robust discussion in June and July. So very quickly, I'm not going to go through all 80 pages of our first issues paper, but we examined the provisions of the law of the Sea Convention and, of course, customary international law. And I have to say we're relevant, the 1958 Geneva Conventions. Important, as I mentioned, one of the issues concerns the nature of the baseline, whether it's ambulatory, whether it can be fixed, whether there are obligations to update any changes made on charts and notifying these to the Secretary General and to states. So the general rule under the law of the Sea Convention is that, except where otherwise provided under the convention, the normal baseline is the low water line along the coast as marked on large-scale charts officially recognized by the coastal state. And then there are a number of exceptions where the straight baseline can be used, quite a few under Article 7, Article 6, in the case of islands situated on atolls or having fringing reefs, the situation of a river that flows directly into the sea, and also the situation of bays. So those are situations of where the exceptional straight baseline is used. And the question again is whether these are permanent or are they ambulatory? And we know that the 2012 Baselines Committee did take the view that the baselines are ambulatory on a personal level. I'm not sure I necessarily agree with that, but it's an important starting point. And then we look at, of course, where in the convention permanence is reflected, and that is in Article 76 concerning the continental shelf, where we know that states there that the coastal state shall deposit with the Secretary General of the United Nations charts and relevant information, including geodetic data permanently describing the outer limits of the continental shelf. And then the language of final and binding is also included in relation to the establishment of the extended continental shelf based on the recommendations of the report of the Commission on the limits of the continental shelf that shall be final and binding. So again, what I'm just trying to do is give some highlights. So some preliminary observations, and we didn't make conclusions yet, and I underline that because it's still early. These are observations. And some of the observations that we made, number one is that, well, at the time that the Law of the Sea Convention was negotiated, sea level rise was not an issue at the time. And for those concerns where permanency would be important, such as in the case of the continental shelf, it was addressed. So the ambulatory theory or method regarding baselines and the limits of maritime zones measured from them, however, do not respond to the concerns expressed by member states that are prompted by effects of sea level rise. Another observation, an approach responding adequately to these concerns is one based on the preservation of baselines and outer limits of the maritime zones. The convention does not prohibit expressis verbis such presentation, and that basically, another observation, the convention does not indicate an obligation to draw and notify new baselines when coastal conditions change, or as a consequence, new outer limits of maritime zones measured from the baselines. Now, I know we have time limits, so I want to just focus some on the maritime entitlements. One of the issues too is that if the baseline is ambulatory, and if it is to move landward, this has an impact on the location, and it would mean the transition of the maritime zones. And so that would change the zone itself. So part of the internal waters would become territorial sea, part of the territorial sea would become exclusive economic zone. And then particularly in the case of the exclusive economic zone, that means what was once under the sovereignty rights of the coastal state, we can't say how much exactly, but part of it at least would become high seas, an open access regime. And that has huge consequences economically, socioeconomically. We know that fisheries access agreements are very important for many developing states. Also, from the environmental perspective, marine protected areas that have been established exclusive economic zone. So I'm just highlighting. And of course, we have the very important issue of islands and rocks, as I mentioned earlier. Would an island devolve into a rock under the convention? And just one, for example, observation we made, and we looked at state practice, and it's clear that state practice is really not very clear on this point, on what the status is. We have very few case law on that, except for one arbitral award. So the preservation of maritime entitlements for islands that lose their capacity to sustain human habitation or an economic life of their own due to sea level rise does not entail creating new rights, but only would maintain existing ones. And this would preserve the existing balance of coastal and third state rights. And so that's just one preliminary observation. We also looked at land reclamation activities, artificial preservation. We had our first meeting of the open-ended study group in June and July. You can read about that in chapter 9. We had a very good meeting. It was very robust, but this work is continuing. This is a work in progress. So I'm going to stop here. As I said, there's much more I could say, and I've tried to give a synopsis, but I want to just say that international law has an important role to play in this. And I agree, it's part of the adaptation role as well. International law is an adaptation tool, and this includes the maritime entitlements and rights. And so what is the role of the International Law Commission? I hope it will be one that will influence finding real solutions. And I'll stop here. And I apologize if I went too long.
No, thank you very much. Thank you, Nilofer. No, you gave us a very, I would say, detailed, although synthetic, because of time limits, landscape of how the situation is today with regard to the law of the sea. I will ask immediately Professor Tullio Treves to react if he wants to what Nilofer has presented. Of course, I ask all the participants to try to keep to their time limits, because this is very important in this type of format, I would say. So Tullio, the floor is yours, Professor Treves.
Thank you very much, Giuseppe. Do you hear me?
Yes.
Yes, fine. Because one never knows how these things, technological things work. Well, I think the report we have just heard from Nilofer illustrates that on the topic that seems relatively narrow, lurk big problems. And perhaps if we look at the work in which the International Law Commission has engaged in connection with the ongoing conference on so-called BBNJ, we see that there is a revival in lawmaking or law proposing activities concerning the law of the sea. Perhaps those who, like me, had been engaged in the negotiations of the Law of the Sea Convention of 1982 for about a decade, and then in the work of the International Tribunal for the Law of the Sea, might have thought that with the 1982 convention, this phase, the codification phase, the lawmaking phase, was over. And then now we were moving into a phase of adaptation to new circumstances without fundamental changes. Perhaps what is going on now still can be framed in this from this viewpoint. Most of the conventions concerning law of the sea matters adopted after the Law of the Sea Convention in '82 are keen on specifying that they are without prejudice to the Law of the Sea Convention. So are apparently the negotiations going on in New York. And I suspect that in the International Law Commission, at least some voices will have been raised. Let's not, let's say, question the big framework that is the Law of the Sea Convention. Still, the fact of sea level rise poses complex questions. I think that before, let's say, being too sanguine about, for instance, in particular, the alternative between ambulatory baselines and permanent baselines, some facts should be dug. We should know how many meters or miles are we talking? Sea level rise of eating up 1 meter of beach is not the same thing as sea level rise eating kilometers, and moving consequently by kilometers the lines delimiting the territorial sea and the other maritime zones. So I think that the discussion would be very much helped by some study of how big is the phenomenon. This certainly would make the question of ambulatory versus permanent baselines less dramatic. Still, there are certain aspects that are unavoidably dramatic. In particular, I would, thinking of what was said by Niloufer, the question of rocks under Article 121, paragraph 3, that could very easily disappear, is indeed full of impact. Last point, I don't want to take away the time to other possible interveners. I'm sorry. A last point I wanted to mention is that sea level rise may have an impact, especially on the maritime areas close to the coast, internal waters, territorial sea, much less on the exclusive economic zone, or even less on the continental shelf, because these are very, very broad areas. And a change of a few hundred meters in most cases doesn't matter very much. Still, some consideration should be given, and it is being given according to what we have just heard, to the possibility of updating the data on which, for instance, navigation is conducted. There is, in my view, nothing in the convention that would be against agreeing that the charts must be updated every 20 years or something like that. So I think that it is a wonderful work that Niloufer and her companions of this adventure are conducting. I wish them very good voyage. Still, it would be important that the quantitative impact of what they are discussing be explored. Thank you.
Thank you very much, Tullio. And yes, I think that also for this reason, the contribution of scientists is extremely important to the work of the International Law Commission in this regard. And now I'll give the floor to Elena, because now she has to do something. And I recall to everybody, to all the participants who are almost 130 now, which is a good number. And I see participation also from other parts of the world, not only from here, from Europe. I was saying that those who want to make questions, they can do it through the chat box in this page. And then these questions will be read afterwards. So, Elena, the floor is yours.
Thank you, Professor. So there's something that I have to do is invite actually Professor Davo Vidas to present the state and the coast legal implications on the continuity or loss of statehood. And just to say that this topic is crucial since the consequences of sea level rise in the medium-long run really have revolutionary repercussions on the very existence of coastal states, as well as on basic principles of norms and norms of international law in the field of statehood. So, Davo Vidas is a research professor at the Fridtjof Nansen Institute in Norway. At the, at the International Law Association, he's the chair of International Committee on International Law and Sea Level Rise, and was a member of the International Committee on Baselines under International Law of the sea. Professor Vidas's experience in international law includes also acting as counsel and advocate for the government of Croatia and holding advisory positions in key international organizations, such as, for example, the International Maritime Organization. In conversation with Professor Vidas will be Professor Nesi, Giuseppe Nesi, who is full professor of international law at the University of Trento, where he was dean of the School of Law. He's the general editor of the Italian Yearbook of International Law and was the legal advisor of the President of the General Assembly and of the Italian mission to the United Nations in New York. So enough with the introduction. So Professor Vidas, you have the floor. Thank you.
Thank you very much. It is a great pleasure to be here with you, even if online only, and I would just like to make sure that you hear me. So if you do, that is great. And really, I will be first saying a few introductory words for this session, and then we will engage in a dialogue. But what I would like to start with saying is that the theme is at the core of international law. The state, its statehood, well, the concept of state, we all know, has been with us ever since the invention of international law. But the context emerging on the horizon is unprecedented. That is the context of sea level rise. Of course, it is unprecedented for international law and its history, but it is not quite unprecedented in the geological history of the Earth. There were, of course, many episodes of sea level rise before. Only there were no states around at those distant times of the past. So some time ago, lawyers increasingly started to realize that due to sea level rise, we may be, in a way, returning to the past, and that we need to start thinking about the coming decades, since we can again experience a serious amount of sea level rise, and that to be for the first time in our written history. So Before addressing the theme of the statehood and sea level rise, let me first briefly introduce an expert group which has this matter on the agenda. It has been mentioned already. This is the Committee on International Law and Sea Level Rise, which is a committee of the International Law Association. The committee is actually one of 20 current committees of the ILA. It was established in 2012, and it today has many members from various ILA branches. We are very happy to have also the Italian branch now represented, but there are several other participants in this panel who are members of the committee. As a sort of an abstract or essence, I would say that our committee is very much about looking ahead and seeing a fundamental change on the horizon, a change for which we must start preparing in advance, and we must try to do this systematically. This way of looking at options for the development of international law is still perhaps a bit unusual. But facts are changing, inevitably, and the law will have to react to this change. International law will also have to adapt and also change. And in this process, I trust that international law scholarship may have a unique role. It may be able to look a step or two ahead and assist with conceiving options for legal responses. Perhaps not final solutions, but bridges on the way to some solutions in future. This is in essence what our committee is about. The mandate of the committee, as it was formulated in November 2012 by the ILA, is twofold. First, it is to study. Second, it is to develop proposals. The study concerns the possible impacts of sea level rise and implications under international law, in particular for small island and low-lying states. And the development of proposals concerns the progressive development of international law in relation to the possible loss of all or of parts of state territory and maritime zones due to sea level rise, including the impacts on statehood, nationality, and human rights. So these were the quotes from the mandate which we got. And we have seen already in the introductory presentation today by Thomas Frelich what is today a scientifically established fact. That is, while the rate of progression of sea level rise for the next decades of this century is still somewhat uncertain, there is one key fact. Whatever way turned, a serious amount of sea level rise is unavoidable before the end of this century, whatever way we turn, regardless of the scenarios by the IPCC. And this is a major change compared to the past 6,000 to 7,000 years. This is what geologists tell us. And this change is already inbuilt in the reaction between the atmosphere, oceans, and polar ice. This is how the Earth system works, with ocean as a buffer, but as a buffer only for some time. We therefore do not speak simply and only about future. We in fact speak about future only insofar present condition of the Earth system already taken up by the oceans will be manifested in sea level rise in the next few decades. So that is future, but a future that is certain to happen. And this will bring many consequences beyond just international law. But this matter, or this change of facts, is highly relevant for several areas of international law, and it requires study interlinking different parts of international law. So with all this in mind, our ILA committee has already at its first meeting in Washington, DC, that was in April 2014, we have identified three key or critical issue areas. First, the law of the sea. Second, forced migration and the rights of the affected populations. And third, issues of statehood and international legal personality. We then also agreed to address our mandate through two main phases. The first stage, from 2014, involved two parallel streams of study. One was on the law of the sea, and the other on forced migration and human rights. That stage was completed with the 2018 report of the committee and two ILA resolutions, which were adopted by the 78th ILA conference in Sydney in August 2018. Since 2019, we have entered the second phase of the committee's work. This stage includes the study of the statehood question, or more broadly, of issues concerning international legal personality in circumstances of sea level rise. The distinction between the two phases of our work is not only thematic, it is also in the focus. Until 2018, the committee focused on priority areas in a relatively shorter term perspective, especially regarding aspects of the law of the sea and of displacement of persons in the context of sea level rise. Since 2019 and now, the focus of the committee is more on the issues emerging in the mid to longer term perspective. And in this second stage, we thus currently also focus on the study of statehood. So let me now touch upon at least some general considerations regarding the current work of the committee on those questions. Any conclusions regarding these matters will have to await, I must say, the publication of our final report in the summer of 2022. But at this point, I am happy to share with you some of the emphasis and some of the dilemmas involved, of course. First of all, I wish to emphasize that the committee is not dealing with the question of a state and statehood in abstract terms. These issues arise in a very specific context, the context of island and archipelagic states, and of some low-lying island states in the Pacific and Indian Ocean in particular. Also, consequences for different aspects of statehood of those states are expected to occur in the course of a longer-term process. From these two basic considerations, framing the discussion by the committee regarding statehood follow. The first consideration relates to the category of states concerned. They are not just any states. These states have a very specific feature under international law. The essential aspect here, as related to sea level rise, concerns the relationship between the notions of the state and of the coast. A state may, of course, have statehood without having a seacoast. There are today, as we know, about 50 such states, and they are called landlocked states. Likewise, a coast may exist without there being a state on it. As we all well know, an entire continent, Antarctica, has been governed over the past 60 years, and I would say successfully governed, on the basis of an agreement to disagree on the sovereignty claims made there. But these issues are beyond the focus of the committee. The real question facing the committee concerns the situation in which the coast and the state are necessarily and per definition inseparable. That is the issue of the coastal state. Therefore, the committee focuses on the statehood of a coastal state rather than a state in abstract. And indeed, to retain the status of a coastal state, such a state must retain a coast of its own, a coast under its sovereignty. But there is a second consideration, and I would say that it is equally important. That consideration concerns the time perspective during which the question of retaining the status of a coastal state will arise. Changes in this regard are expected over a longer period of time, on a scale of decades, possibly even centuries, with different aspects of statehood of the coastal state becoming critically affected at different points of time. In the course of this process, key factual elements of statehood will not necessarily be equally severely threatened by sea level rise at the same time. We here, of course, speak about the territory, and in this context, the land territory of a coastal state as a precondition for all the adjacent spaces, and about the population of the state inhabiting that territory. Recent studies have found that for most atoll islands, habitability will be threatened as soon as the middle of the 21st century, this century, 30 years from now, which is far sooner than indicated by studies that focus on the permanent inundation of these same islands. Now, the basic considerations those are the basic considerations that inform the focus of the committee in its work. What the committee is looking at is the gradually diminishing statehood, and more specifically, the diminishing statehood of a coastal state, that is of island and archipelagic states. What we are looking at is a slow impact phenomenon that is likely to continue for decades, even centuries, also after the end of the century. And we must be aware that changes will be ongoing through different phases. Therefore, also the study by the committee is oriented on considering a range of interim approaches or strategies, rather than attempting a definitive, once and for all proposed legal solution, which we must be aware would likely be elusive. And I think that I would, for now, leave it at those rather overall considerations, which are leading the work and informing the work of our committee concerning the question of statehood. But I will be, of course, happy now to return to any specifics in the course of our dialogue and later questions. And thank you so very much for your patience and for your attention.
Thank you very much, Professor Vidas. Thank you, Davor. And I think that there are already maybe some questions that can be put forward. One is regards the possibility of enlightening us on the different views of the International Law Association committee members on the impact of sea level rise on statehood. And in the positive, whether those different views can be identified into discernible camps. This is a first question that I think we can put to Professor Vivas. And then you also made reference to the acceptance by states of the fact that changes in the main feature of statehood due to sea level rise could play a constitutive role rather than a declaratory one. My question is, what exactly will be constituting, assuming that existing states will continue to exist? And I also appreciate very much this reference you made to the different approach that could be foreseen. So the refusal of a one-size-fits-all approach that is also very wise from the legal point of view, and also looking at the scientific data. So I don't know whether you want to answer to this question now, or we can delay these answers, but it's up to you.
Thank you very much. Thank you, Giuseppe. Yes, I appreciate, of course, the questions, and I was thinking about the number of our committee. We are 45. I don't know whether I mentioned that, and therefore, if we would ask about the legal views, we always risk to have at least 45 views. when we have 45 lawyers. And we really do have a diversity of views. I think that we are, in a way, all aware of those basic propositions. But if I would wish to try to distill all those views regarding the termination or continuity of statehood, I think that I could say that we have two main approaches, really. One approach is based on the argument of strong presumption of continuing statehood. So that this should be the starting point of any consideration of this question. Then the other approach is based on the argument that as states are territorial entities, a state without a territory is not possible. And that therefore, if a state loses its territory or its permanent population, its statehood terminates. Now, there is one key consideration which I would like to emphasize, which relates to either of those two very broad groups of views. They both, rather than offering a starting point, they are referring to what will happen at the end point of a very long-term process. So those scenarios are at least several decades away. I would not say at best, but at worst, and more. Probably we are talking in many cases about the next century. Therefore, I think that what the committee deals with is a mid to longer term development in the course of a process extending from now, from present time, and towards this end result. We cannot now create an end legal result or propose an end legal. I mean, we can, but that will have not much impact, really. That means all until the point when a land territory of a coastal state has been totally submerged at some future undefined time, there is a very, very long time in between. And I think that there is a very clear realization in the committee of that circumstance. Also, I would like to add that there are many shared views, not only differences on those key subjects. First of all, we do agree that we are addressing a specific and unprecedented legal situation. This is unlike any previous cases of termination of states, which resulted from political changes or processes. What we here have at hand will come as the consequence of natural Earth system change, Earth system processes. It's a big difference. Of course, it will have political implications, but changes are not induced by political reasons. That in itself makes the situation of those states distinct and separate from all other reasons of lack of territory in international law, including those which might otherwise be used for different, and I would say including for various political purposes. And then finally, and equally important, there is a shared sense of importance of underlying reasons within the committee. Those are serious reasons that justify consideration of a specific legal solution for states affected by sea level rise. And among those reasons, I will wish to mention fundamental justice and fairness, indeed, self-determination of peoples, and last but not least, the overarching objectives of international law to facilitate stability, as already Nilofer has mentioned before, and several, stability, certainty, predictability, and all this in the interest of avoidance of conflicts and of the ultimate role of international law of maintaining peace and security. So those overarching objectives, they will persist regardless of any amount of sea level change. Many factual things will be changing, but those objectives are those which will be I assume, leading the work of some future generations of lawyers, which will come to tackle this issue area. So what we are doing, I believe, we are only trying to provide material for early bridges towards some future solution. I think maybe I stop here with responding. We could be responding on and on and on, but it's maybe those basic considerations for now.
Thank you very much, Davor. Yes, I think that we have to be all grateful to the International Law Association for the work that has been done by the ILA, and I'm sure that also the International Law Commission members associate themselves to these thanks to the ILA. And at this point, I take again the hat of somehow trying to have smooth communication among us, and I thank Elena again for what she has done. And I think that we are now ready to address the fourth session of our meeting, the one that is devoted to forced migration and the rights of the affected population. Two distinguished speakers will take the floor, one as rapporteur and the other as discussant, but I think that they will repeat also the formula of having a sort of conversation. The first is an old friend of mine, Patricia Galvao-Teles, who is a member of the United Nations International Law Commission and co-chair of the study group on sea level rise in relation to international law. At the LC, she was also the general rapporteur of the 70th session in 2018 and chair of the drafting committee at the 72nd session in 2021. I would like to congratulate Patricia because I think that she was the first woman who was the chair of the drafting committee. She's also an associate professor of international law at the Autonomous University of Lisbon. She's a member of the Permanent Court of Arbitration and is currently vice president of the Portuguese Society for International Law. She's also adjunct senior researcher at the Center for International Law of the National University of Singapore and co-director of the Center for International Law E-Academy in Singapore. She has also recently become a member of the Institut de Droit International, and also for this reason, I think that we have all to congratulate her for this important recognition. Patricia, before giving you the floor, I have also to introduce Elisa Fornalet. Elisa Fornalet is Swiss National Science Foundation professor at the World Trade Institute of Bern. I again have to say something on a personal basis, which is very, very moving to me, because Elisa got her law degree at the University of Trento some years ago, and I was the director of her thesis. So I'm very happy that one of my former students is a professor abroad in this moment. Elisa is implementing the SNSF project, framing environmental degradation, human mobility and human development as a matter of common concern. The project aims at identifying the climate mobility nexus change through a pilot case study in the small Pacific Island states. In May 2021, she has been appointed as co-rapporteur of the International Law Association Committee on Sea Level Rise and International Law, and she is an appointed member of the Advisory Committee on the Platform on Disaster Displacement. So I would start giving the floor to Patricia, and I guess that there will be a sort of ping pong between her and Elisa during these, I would say no more than 15 minutes, because I still hope that there will be some time for Q&A, although at the moment it seems that everything has been clarified by the rapporteurs, because I don't know there has been any question at the moment. However, Patricia, everybody is following us very, very closely. This means that you have even more responsibility since we are here since 3 o'clock, and after 1 hour, 40 minutes, there are still 120 participants in our webinar. So Patricia, the floor is yours. And thank you very much again for being here.
Thank you so much, Giuseppe, and thank you so much for the kind, warm words of introduction. And I'm very grateful to be together with so many good friends and colleagues in this panel. And I think it's been excellent so far. I'm also very grateful to be interacting in this last part with Eliza Fornale. And indeed, we had prepared something because maybe coming at the end, we thought we would do something a little bit different. So this will be a conversation rather than a presentation from my side, and I think I'll yield the floor immediately to Eliza for some introductory remarks, and then we'll do a conversation. But again, I'm so happy to be with such esteemed colleagues from the Commission, from the ILA committee, where I'm also a member, and with you, and I'm very thankful to all the organizers for this timely event. So in order not to lose time, I'll stop my initial remarks here, and we'll go straight to the discussion. So Eliza, up to you.
Okay, thank you a lot, Patricia, and good afternoon, everyone. First of all, I would like to thank you, Professor Nesi and Professor Fasoli, for bringing us together, because I think it's a very important topic to focus specifically on the role of international law in the context of climate change and sea level rise. And it's really a great pleasure for me to join this webinar and also to introduce this last section, because as Thomas explained, I think the scientific evidence now leaves really little doubt that exposure to slow onset events such as sea level rise is leading to negative effect on the affected populations. And this is resulting in particular in forced mobility within countries and also across borders. So in particular, I refer to the inhabitants of small island states and also of coastal areas that will be exposed to substantial impacts. Just few data, I remember that the Internal Displacement Monitoring Center reported that in 2020 alone, the number of disaster-related internal displacement in Vanuatu was 80,000 and in Fiji was 37. And if looking at the projection for the future, sea level rise in Bangladesh, for instance, could affect 70% of the country, and 20 million people will risk losing their homes. So this reality, I think, really illustrates how the present, but also the future impact of changes in sea level could interfere with the full enjoyment of human rights, in particular the right to life, to safe drinking water, or the right to self-determination, by creating new protection gaps. So as said before also by Davor, international law scholars are making progress in understanding whether and how existing regime could offer some degree of protection for those who move or also who are at risk of moving. But as recorded by Davor, so it's important to remind that since 2012, the International Law Association Committee has worked on these themes, and its initial focus has been included in the Sydney Declaration on the Protection of Persons Displaced in the Context of Sea Level Rise, adopted in 2018, which aims in particular to offer guidance to states in averting, mitigating, and also addressing displacement in the context of sea level rise. And now the committee is really engaging with the mid and long-term issues related to this topic. But despite this significant development, the question of how international law could address the complexities of the issues is still under discussion. And I think it's a great honor to introduce Patricia to really address this topical issue. And now I would like really to invite Patricia to illustrate the role of of the ESC in relation to this subtopic, starting by looking back, I think, at how it came to be included in the work of the ESC, and maybe also if it's possible to discuss a little bit the connection that we can also identify with the previous work of the ESC, in particular with regard to the protection of people in the event of disasters.
Thank you so much, Elisa, for making us looking back. I think it's important, and Nilofer has already explained very well how the topic as a whole came to the agenda of the Commission. So I'm just going to say that she has explained everything that had to be explained. Of course, we could discuss this also from the point of view of the working methods of the Commission and the study group and all of that. But I think the important point here is to understand that there was very strong support from member states in the General Assembly. And indeed, not only that support was expressed informally, also formally in statements before the Sixth Committee, but there was even a very rare occasion where a member state, the Federated States of Micronesia, and I think one of the key persons behind this initiative for Micronesia is also attending our event today. So I wanted to say a special word to Clement from the Micronesia mission in New York, because this is also something that the International Law Commission could use more often, to have a state or a group of states taking up the lead and also encouraging the Commission to taking up a topic that is so important if we think about the current challenges that the international community is facing. So a bit on the general context, and Nilofer has explained it extremely well. On the specific issue of this subtopic that I'm responsible for, the protection of persons affected by sea level rise. This is, I like to call it the human face of sea level rise. I mean, we have the topic on law of the sea, the topic on statehood, and this is more visible perhaps to the international community in terms of the human face of sea level rise, how it affects people and what can international law do to help the international community protecting such persons. And so this has drawn very important inspiration, not only, and this was already mentioned by the previous speakers, including Nilofer and Davor, drawn an important inspiration from the work that had already been carried out and is continuing to be carried out by the International Law Association, that was really visionary, I would say, in 2012 in putting the topic of sea level rise first as an offspring of the Baselines Committee, more on the law of the sea aspects, but then taking it also to the other topics of interest. I mean, they're not the only ones. There are other topics of legal questions raised by sea level rise that neither the ILA nor the ILC are covering. But I think these three subtopics as very connected to the own notion of state, the territory, the government, and the population. They make a lot of sense to be treated together. So there's a lot of synergies, and I think this is a very also interesting example of how private public bodies and academia, and I think this type of events are also excellent ways of bringing together, the experts, academics, representatives from governments, and helping us all think on, how can we, and this was already stressed also by previous speakers, how can we make international law as a tool for helping the international community dealing with the climate crisis. And so this is, I think, what we're trying to do, each one with our own mandates and our own specificities, but as a joint and common effort. So the work of the ILA was extremely important in highlighting the issues related to the protection of persons. The Sydney Declaration is a very important document on the duties of the state, the duty to cooperate, the different forms of human mobility and the legal implications. And so, of course, I think this will be a very important point also for the ILC mandate if we look at the syllabus. Another point that I would have to say in terms of looking back, we're not starting, because we have the ILA work, we're not starting from zero, but we're not starting from zero either, as you mentioned, Elisa, because the ILC had already looked at the issue of disasters, trying to give a bit more coherence to this very dispersed area of international law. And it proposed a set of draft articles on the protection of persons in the event of disasters. And in the commentary, we can see very well that sea level rise, but also pandemics. I think it's interesting to note. Sea level rise is a type of disaster, a slow onset disaster, but it's a type of disaster. So the framework that was proposed by the ILC in these draft articles, which are they're not so much about the human rights of the persons affected. There's an article that, makes a general call that human dignity needs to be respected. But then the articles are much more about state-to-state cooperation, about the duties and the obligation of the states, the state affected and third states. So not so much about the human dimension and the human protection dimension, which I think is where the ILA work comes in, and then how where the International Law Commission will also continue that work. So there's a bit as background, the looking back aspect.
Thank you a lot, Patricia. I have a few more questions because I would like also to raise your attention and also to share with us your perspective in line with with approaches that are emerging, for instance, from the work of the UN treaty bodies to try to clarify how human rights could inform also the content of state duties in the context of climate change. So I would like to ask you to say, if it's possible, a few additional words on how this positive development could offer also a basis for the work of the ELC. Also then to turn to the question of which key priorities remain crucial to securing adequate protection and translating human rights obligation into action, and whether you think that also the ELC could provide any guidance on promising practices that maybe can be relevant for other states.
Yes, now as I was mentioning, and your question points to that direction. I mean, one of the important focus of the ILC work on this domain, we are now preparing what it's called in our jargon, the second issues paper. The first issues paper was about law of the sea, and now the second issues paper that will be discussed next year is going to be on statehood aspects and also on the protection of persons. And so with this, we'll have a first tour of the three subtopics. And on the protection of persons subtopic, I am going to be focusing on the legal frameworks, the applicable legal frameworks. And of course, we don't have time to discuss, the different legal frameworks that can come into play when we look at how international law protects, or where there are gaps in that protection. But of course, the human rights framework is a very important one. Not only, of course, in principle, because although we cannot say that sea level rise is a violation of human rights, but we can certainly say that sea level rise affects adversely the enjoyment of human rights and of many human rights, and you've pointed to some. I would say that it does affect the full range of human rights, enjoyment of the full range of human rights, from civil and political rights to economic, social, and cultural rights. And this framework not only is, important as something in principle of a theoretical importance, but also we are seeing now that also because sea level rise is already happening in the ground, and this was a point that was emphasized not only in the setting of the scene, the presentations that were very good, but also as Nilofer explained, and Davor, I mean, although statehood is a bit more, long-term, but in law of the sea and also in the impacts from the point of view of persons affected, this is already happening. So it's not surprising that we're seeing more and more cases in the human rights framework where people are approaching, for example, human rights treaty bodies with complaints. And we have, and this is a very, I think, the first decision that it's specifically dedicated to the issue of human rights and sea level rise, not climate change in general, but sea level rise, which was a complaint that was brought by a citizen from Kiribati to the Human Rights Committee, the Tetiota case, where Mr. Tetiota had been in New Zealand, and he was deported back because he tried to apply for refugee status, and it was denied, and it went all the way to the Supreme judicial institutions, and then Mr. Tetiota ended up by being deported by New Zealand authorities back to Kiribati, and then he presented a claim before the Human Rights Committee. Of course, it's not a judicial body, but it's a body with a lot of authority under the Covenant on Civil and Political Rights. And the claim was basically made on the basis that returning back to Kiribati with the impacts of sea level rise and the adverse impacts, especially on the right to life, and the prohibition of torture, cruel and inhuman and degrading treatment, so Articles 6 and 7 of the ICCPR, they were jeopardized, and also the Human Rights Committee recognized that the principle of non-refoulement, which is something that we know normally from refugee law, but also exists in international human rights law and in customary international law, would offer a protection. So it would impose a duty on New Zealand not to deport back to Kiribati Mr. Tetiota because of the risks to the enjoyment of the right to life and the protection from torture, cruel and inhuman treatment. But there was, the decision was not in favor of Mr. Tetiota, because the committee also said that this is not yet the case. Maybe in 15 years, the protection of non-refoulement would come into full play, because we're not there yet. But the time frame that the Human Rights Committee gave was one of 15 years, 15, which is not too long from now. So this is, I think this is an important message that the Human Rights Committee has given us in terms of the applicability of the ICCPR to this type of situations. And there's more coming. There's a complaint by a group of children before the Committee on the Rights of the Child. The case is called Sachi and all. But one of the children is Greta Thunberg, very famous Swedish teenager that started the school strike movement. And there are also some children from Pacific Islands. So there's also a focus on that complaint about sea level rise and the impact on the rights of children. There are also the general comments of the Human Rights Committee. For example, General Comment 36 on the right to life also addresses this issue. And there's a comment coming up. The Human Rights Committee said that it was preparing a comment. It will come out very soon, I hope, probably in 2022, on children's rights and the environment, with a special focus on climate change. I think this is another area, because climate change is very much about the rights of the present, but also very much about the rights of future generations. And so the framework regarding children is very important. And I could go on and on with examples from the human rights area. The Human Rights Council is adopting constantly resolutions about human rights and climate change. There's now an attempt, and I think it's very near, of having a special rapporteur on human rights and climate change. And this has been a flag of Pacific Island states that are more and more active in the framework also of the Human Rights Council. There's, for the first time, Pacific Island country, Fiji, has a chair, Ambassador Nazat Shamin Khan, that Nilofer and I had the pleasure to host in Singapore for a distinguished lecture series, and we spoke about this issue. So it's very important for the agenda of the PCIDS also to use the human rights machinery for also highlighting and mainstreaming, and we're seeing some results in terms of the general comments and cases coming up from the treaty monitoring bodies. So this is something certainly that I'm going to be looking at in my report for next year. So I will stop here for now, and you will have to read the report afterwards when it's issued.
Okay. If I can use a few more minutes, I hope it's possible.
Yeah, we are running out of time, but there is still a lot of people here. But if you want just for a very short point,
I will conclude.
Because we have also one question that should be answered before the end of our webinar.
Okay, so really, I will conclude, look into the future, I will say, because we conclude our journey also with a final question, because I would like just to invite now Patricia to conclude by addressing, I think, one of the key priorities that has important implication for our topic, and I think is the need to strengthen international cooperation, because as recently highlighted, is particularly by the UN Secretary General in his annual report, the pandemic has also been the greatest shared global challenge for the UN, and he has tested multilateral cooperation to the limits. So given that the climate change has been defined, and I refer, for instance, to Professor Brunet, who identified climate change as a complex action problem that requires collective and coordinated responses, I would like to ask you really, Patricia, to identify what limits will the international community also face when addressing displacement and protection needs. So I would like to close with this final question, if we have still time.
Yeah, Patricia.
I will be very, very brief, because I think I would need a lot of time to explain this, but I will only say two things also as a teaser for my report, but I don't think I'm going to be able to deal with it in the first paper that we'll be producing. I think this has to be maybe for a bit later. But with regard to international cooperation, I will say two things. One thing is that from a practical point of view, a pragmatic point of view, it's the only way. I mean, I think it's the only way. I mean, the states affected, directly affected, states that are indirectly affected, and the international community in general. I think this is the only solution for finding the legal solutions and finding the political will and finding the practical solutions is going to be through international cooperation. Even if we look at that also, mainly from the regional point of view, I think the regional cooperation will be extremely important in states in a certain region, more affected region, especially in the Pacific, but we also have the cases of low-lying states that are not island states, but the low-lying coastal states who will need, and then because there will be movement, not only internal movement, but movement outside the borders. So indeed, this has, I think it's only going to be through international cooperation that we're going to find a solution to the protection of persons, because, most states will not be able to handle this on their own, and there will be a need for practical, pragmatic regional cooperation, but with a global understanding. And the other point is that I think we need to work more, and we started doing that with the protection of persons in the event of disasters, but I think we can work more on trying to understand legally what exactly cooperation means. So what's the duty, and what are the limits, as you were saying, or what is the role of the non-affected states? So what is the duty in terms of legal framework? Is it a duty to provide, to offer assistance, to respond to assistance? How can this be done, in practical terms? How do we translate the duty to cooperate legally, so that we have a stronger legal framework and more clarity, both from, because these principles are already in international human rights law and international disaster law. So I think we need to take a more granular approach to try to understand a little bit better what are the contents, the contours, the legal contours of the duty to cooperate and apply it to sea level rise. So I'll just say that, and I know we're rushing, but I'm sure, as you said, Giuseppe, this is only the beginning of a conversation, and will certainly continue. Thank you so much.
Thank you very much. Thank you. It was really very, very interesting. All the interventions, all the contributions. And I think that along the lines of what has been indicated by Patricia at the very end of our webinar, we have maybe to think about this concept of mandatory multilateralism that has been emerging in recent times, for now only among scholars, but I think that maybe states should go back to think about also this issue as regards future cooperation. We have a question, and I don't know who wants to answer, but the question from Wilson Okoye is the following. Global warming as a result of multinational company activities is a certain contributor to climate change and indeed rising sea levels. Wilson asks, what treaties are being developed for states to encourage sustainable practices by multinational corporations within their respective territories? Of course, we could start a long, long discussion about the role of multinational companies and the role of states in implementing and controlling what multinational companies do. But if anyone has just a flash to answer this question, I give the floor to who wants to intervene. Nilofer, floor is yours.
I'll be brave.
Expecting you to intervene.
I'll be brave. It's a very good question, important one. I'm not sure I can do it justice, but I think we have to look to the Paris Agreement. The Paris Agreement is the starting point. The UNFCCC, that is really where the states have the mandate to take the necessary actions through now we have these NDCs. We have climate litigation going on at the domestic level. We know that certain companies are now being targeted, actually. So I would say, it's not we need new multilateral agreements. I think we have to look at what exists. And certainly the Paris Agreement is a good starting point. So that will be my attempt at answering the question.
Thank you. Thank you. No, I would have said the same, but I thank you very much that you came in and said how these system of guarantees of cooperation could work in the future as regards the commitment of states to fight any type of activities that could affect global warming. Of course, it is up also to the states to do their homework in order also to be more authoritative in trying also to limit the consequences of the activities of multinational companies. However, I think it has been really a great webinar. We spent 2 hours and 10 minutes. It's unbelievable. I thought we just started. And of course, many issues have emerged that I'm sure will be dealt again and again in the near future. However, I am really grateful to those who intervened because really in a very essential manner, but also in a very constructive manner, we all addressed some of the main issues concerning the climate change and sea level rise. I'm sure that there will be time and other occasions to meet and to discuss these issues. And I really hope that this constructive spirit that is inspiring us today will be transmitted also to governments and to those who have to make very important decisions in the near future as regards our common future, and that has to be protected by, first of all, by ourselves, I would say. However, thank you very much indeed for your participation. We will have other chance to meet and to discuss, but I'm sure that today's contribution has been appreciated by those who the patience of being with us until now. So thank you again, and all the best for the future.
Thanks a lot. Thanks a lot again.
Thank you.